and welcome to a Newsflash episode of Unpacking the Case, the podcast by Davitt Jones Bould, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape. Hello, Richard.
Hello, Lizzie. How are you?
I'm well, thank you. How are you?
Okay, it's quite a nice day here.
Good to hear it. Well, it's a nice day to talk about changes in the buy-to-let market, which is what we're here to do. I'm specifically talking about the Renters' Rights Bill. So do you want to start by telling us a bit of background around this topic?
Yeah, I'll go back in time to when I was a young boy. And the assured tenancies, and assured shortholds were a type of assured tenancy. And they came into force on January the 15th, 1989. The 88 Housing Act came into force the relevant provisions came into force that day, and created an assured and assured shorthold tenancies. There are a few exceptions, things that can't be assured tenancies, or there will be explanatory notes to the Renters' Rights Bill, doesn't seem to understand them. Things like student accommodation, but it's got to be let out by a specified educational institution, universities and the likes. And I suppose in terms of work that DJB does, things like holiday lets accepted. Mixed business residential properties come within the business tenancy regime. You can, since October 2015, create a home business tenancy. Remember, we've done a couple of podcasts on that. We did one quite recently, Kensington and Chelsea and Melcraft. It was a director of a company who lived there, and it was business tenancy. It was within the 54 Landlord and Tenant Act. And we did one, Annington Properties.
Yeah.
Near where you live, which has been heard by the Court of Appeal now, and we're waiting a judgment. Similar, mixed business residential come within the business tenancy regime, unless it's a breach of the user covenants or just taking work home with you. But you can create these things called home business tenancies. And I suppose in terms of DJB work and the likes, the other one is a major one, there are others besides, is local authorities. Housing associations can and do create assured tenancies, but local authorities can't. And there's always a bit of a pitfall there, a bit of an aside to the Renters' Rights Bill. There was a case called Basingstoke and Dean Borough Council in Pace back in 1995, Court of Appeal case, where it was the local authority had let out premises and it had been sublet. The let out premises was business and the sublease was residential. It was an assured tenancy. And the business tenant surrendered the mean lease, the intermediate lease. So the local authority became landlord of the residential occupier. They can't be an assured tenant. They became a public sector secure tenant with the right to buy. So there is a bit of a pitfall for local authorities and what you do in those circumstances. But that's some of the background. Shall I tell you what has happened of late?
Yes, please, update us.
Yeah, well, there's a renters reform bill that the Conservative government, and Michael Gove, if you remember him, whatever happened to him, introduced in May the 17th last year, which was intending to get rid of assured shorthold tenancies where you can serve Section 21 2 months' notice, terminating no earlier than the end of the fixed term unless there's a break, and also can't be served until 4 months into the tenancy agreement. That was slowly plodded through Parliament. It only got to first reading in the House of Lords. It had been through the Commons when the election was called, and it didn't pass through Parliament when Parliament was prorogued on May the 24th this year. But Labour said they were going to resurrect it with changes. And on September the 11th, the Renters' Rights Bill was introduced into Parliament. It gets second reading on October the 9th. So it's a long way to go. They're expecting the relevant provisions to become law probably next summer. And with the majority that Labour have, I don't think it's going to be a doubt of it. It will become law sometime next year, certainly. And it does change the whole buy-to-let investment market quite dramatically. Shall I tell you some of the changes?
Yes, please.
It's 146 sections, clauses, I should call them, long, and 5 schedules. If you were to print it out, don't, because it's 266 pages. And I say it does lots of things which are sort of marginal, to say the least, to what we're talking about here. But it states, and this is going to be different the way they're implementing this than the original Renters Reform Bill, but it's they're going to make all assured tenancies periodic, with a period equivalent to the rental payments, but no more than a monthly period. And that's going to be retrospective. It's going to apply to all fixed term tenancies which are in existence whenever this legislation comes into force. And quite controversially, the tenants can serve 2 months' notice at any time from day one, which is an issue in relation to, for instance, student accommodation, most obviously, because student accommodation tends to be, for the academic year or for a year. And if the students don't like the property or don't like the course or whatever, they can just give 2 months' notice and enter into the agreement in September and be out of it by November, with the landlord probably having an empty property, possibly having an empty property for the rest of the academic year. That's the previous bill that didn't get through Parliament was going to state that the tenants would be there if it's definitely would have to be there for 4 months in student accommodation. That's not in this particular bill. There is provision, however, in relation to student accommodation where you're a full-time student in a house in multiple occupation, which is basically where you've got 3 or more people, 2 or more households, not related, and they share facilities, a kitchen, sort of a bathroom, bedrooms if they're lucky, but and they're not related in those circumstances, then there'll be a ground for possession that if the students don't leave between June and September, you'll be able to go to court and have a ground for possession to be rid of them. But that's only houses in multiple occupation and full-time students. And so it's going to have a massive bearing. Lots of student accommodation is a house in multiple occupation. The actual guidance notes also say that if you've got purpose-built student accommodation, both in the public and private sector, and universities and the likes, plus the private sector, they're not assured tenancies, and that's just wrong. If the private sector, they with one exception, which needn't bother us, they are assured tenancies. The other things they're doing is most controversially getting rid of non-fault evictions. This has been in the news, Section 21 shorthold notices. And that's going to be retrospective unless you've served a notice seeking possession before the legislation comes into force. You won't be able to serve 2 months' notice no earlier than the end of 6 months. That's got a bearing for existing properties as well, actually, existing tenancy agreements, because you can't serve a shorthold notice until the lease is 4 months old. Let's say the legislation comes into force in June the 1st of next year, which is quite possible. It means that anybody entering into shorthold tenancies in February of next year won't have had the 4 months before the legislation changes. So they won't be able to be served with 2 months' notice. Shall I go on?
Yeah, are there any other changes in the market?
We're also changing the grounds for possession. Currently, for instance, there's defined rent arrears, which is 2 months rent arrears when you serve your notice seeking possession, and 2 months when you go to court. And you have to have 2 weeks between the two. That's going up to 3 months, 13 weeks if you pay your rent weekly. That's what it was before 1996, when the Housing Act of that year changed it all, actually. And they are introducing new grounds for possession for things like rent to buy, where you're a registered provider of social housing, providing a rent to buy scheme, or supported accommodation, where the person no longer needs the help, sort of disabled accommodation and that kind of thing. And a few others besides. There's also going to be a obtaining possession on development grounds if you want to develop the site, which sounds a bit like Ground F for the 54 Landlord and Tenant Act. And there's lots of other things besides, but that's some of them. I better tell you the situation in Wales. I should have made it clear at the beginning, this is England only. Some provisions do apply to Wales, actually, but not the ones we've just talked about. In Wales, lots of people don't realise in England that they got rid of assured tenancies in December the 1st, 2022, when they were replaced by something called an occupation contract under the Renting Homes Wales Act of 2016, actually. It took a long, long time for it to become law. The gist of which is that you have to give it, well, the tenants have got the right to stay there for at least 6 months. And then after the 6 months, they can be given 6 months notice. There are grounds for possession as well. And that actually applies to student accommodation as well. I know the universities in Wales have had great difficulties adapting, because within 14 days of the agreement, you have to give the pro forma kind of occupation contract to the occupiers, else you can't just serve notice. And it took housing associations likewise in Wales have had huge issues adapting all their existing tenancy agreements to occupation contracts. They hadn't, if it was existing before December 2022, they had until June of 23 to do the adapting. Also, in terms of the grounds, you might be thinking, this is back to England, what if they, how do you get vacant possession if you want to sell? They're going to introduce a new ground 1A, capital A, whereby if you want to sell, you can get possession of the premises. But unlike the original Renters Reform Bill, you can't use it until the lease is at least a year old. And then you have to give 4 months notice. They're also keeping ground 2, which is where the mortgagee wants possession, because otherwise no mortgagee would lend on it if a shorthold tenancies go. And currently you can use ground 2, but you've got to give notice to the tenant no later than the tenancy agreement being entered into, that's what you're doing. You'll be able to use it. Well, you'll have to serve 4 months notice, but you'll be able to use that. And also where landlord or family members want to occupy, but you won't be able to use currently ground 1 until a year into the agreement. And again, give 4 months notice. You want to occupy as your only or principal home or family members. So those are just some of the things, and many more besides. There's going to be things like a decent home standard and a database of private landlords and ombudsman schemes and the likes as well. Decent home standard applies to the public sector at the moment. So, but something called Awab's law, named after some child called Awab, Arab Ishaq, who died because the public sector landlord was not paying attention to complaints about mold growth and the likes in the property. So that's going to be introduced into the private sector as well.
Is there anything else happening then in the world of buy-to-let properties that we should be aware of?
There's a lot of things, disincentives. I remember, the shortholds came in 1989. There was a predecessor called protected shortholds that came in November of 1980. And it seems strange that they're going to go after all these years. On top of that, you've got things like multiple dwellings relief on stamp duty land tax came to an end in June. If you're buying several properties part of the same transaction, even if at different times, you could claim multiple dwellings relief. You can't now. You've got things like, we don't know, but at the end of the month, we've got the budget and various discussions about capital gains tax changes. And in the Labour Party conference, Ed Miliband, who's the Department of Energy and Net Zero, or whatever the name is nowadays, they change their name all the time, secretary announced that the minimum energy efficiency standards would go down from a minimum of E rating, if you need an EPC, as now, to C rating, but not until April 2030 in both public and private sector. And currently, you can apply for an exemption, so a PRS exemption, private rented sector exemption, which also applies to the public sector as well. But you can apply for an exemption in the private sector, at least, where the cost of making the property E-rating be more than £3,500. You only have to spend up to £3,500. They're consulting on bringing that up to 10,000 cost ceiling. I did see something from Savills that said if that's the case, to make all the properties in the country up to C rating would cost about 25 billion. All just the residential properties, let alone the commercial, whatever happens with that. And you're hearing already about landlords divesting themselves of property portfolios big time. I think it happened in Wales just before, when the Renting Homes Wales Act was about to come into force. And it'll certainly happen in England. And that's it, Lizzie, for another time.
Thank you very much, Richard. Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.